Good morning, everybody. Just like to add some footnotes to what has been said by YB Siap. Firstly, about the notion of holding office at pleasure, as stated by the Constitution. Now, when it comes to ministers, holding office at pleasure means that a minister or deputy minister is or may be dismissed at will by the Prime Minister. That's the law. So we have the case of Anwar Ibrahim and Muhyiddin, the most recent one. But for public servant, civil servant, like those who are not cabinet ministers, they are entitled. They must be given hearing. Now, in the case of Gani, obviously he's not a member of the cabinet. He's not an MP. So he is not. He cannot be dismissed summarily by the government. So he must be given hearing. And as has been made it clear by Lawyers for Liberty and many others, including some of the MPs from the AP itself, that the trouble with this sacking is Article 145, Clause 6, which requires the setting up a tribunal. So that is the problem with the sacking of Gani Patail. Now the new AD has said that the sacking does not involve any reduction in rank or whatsoever. We know that because Gani is a member of the judicial and service, so he can be transferred and so on without any reason being assigned to him. But the problem is 145 Clause 6. So now I think the taxpayers, the people in general, are entitled to know the real reason why Gani was sacked or was discontinued as the Attorney General. And I think it's for him now to take the government to court, to get Or secondly, any person with enough locus standi can go to court using I think Article 130. Or the government itself, because in the provision I think 130 of the Federal Constitution, the government, the Yang Tuan Agong may bring a question to the federal court, and the federal court shall issue a judgment in an open court, and that will become the law. Just like when this Kelantan federal government conflict way back in 1968. So that was the only occasion when this provision was invoked, and I think now it's again we have got a good case, and I don't see any other way. I don't expect Gani to put up a case in court, or the government to set up a commission or inquiry or whatever. So I think the only available, and I think the government, as the government that holds the mandate of the Malaysian people, the taxpayers, should allow us to know the reason. And I think the court has got a lot of to say and to do about, because I think the problem with regard to the position and function of the AG is that a lot of history, a lot of conflicting provision in the Constitution. We have had situations whereby years ago during the Rahman, during Raza and Hussein on, the Attorney General at some point were politicians and members of the cabinet. And suddenly, of course, when Mahathir came to office 1981, he changed the position and made the AG as, he took the position of AG as service officer, government officer, which I think is subject to, which I think is difficult because all over the world, including the United States, UK, and so on, the AG is the principal legal officer of the government. He's the chief prosecutor, and he or she must sit in Parliament. In fact, in the UK, both the Attorney General and the number 2, the Deputy, the Solicitor General, both sit in Parliament as MPs. The time has come for us to bring back those days where the AG can answer the question in Parliament himself, rather than the public being given a merry-go-round by the laws. So now we have got Anissa Sukri, saying something else, and then Sukri, saying something else, and then the next day the AG will either confirm or deny that. So this is not good, and I think in the light of we deserve to have more accountability and so on. I think this format is no longer suitable. So I guess the government is duty bound to put this question to the court, and it's up to the court to explain the various anomalies, conflicting position to be found in the federal constitution. And of course, we urge Gani himself to come forward and take up the case to the court.